Hey everybody, thanks for joining us today. We are broadcasting live from beautiful and cold Boise, Idaho. We decided to do this forum live. We actually kind of prefer it. We love to have some sort of engagement. We're fielding chat questions as we kind of go through our presentation. We really invite people to ask questions or provide comments or input as far as, anything that's on topic for our presentation today. So I'd love to be part of this session, and I know we've got a lot of attendees from all over the world potentially. So can we get just kind of some shout outs? Where are people coming from? Would you mind just sending us some chats, letting us know? We'd love to hear from you, hear where everybody's joining from. And oh, we got some chats coming in here. So New York City, Vancouver, Canada, awesome. LA, Richmond, Virginia, hello from Calgary, love it. Chicago, awesome. Las Vegas, Guelph, Ontario, Maryland, Des Moines, Madison, Wisconsin. Uh-oh, somebody does not have audio. Rose Creek, Minnesota, Leland, North Carolina, hello from Alaska, New Mexico. This is awesome, love it. Thanks everybody for joining us today. So without further ado, let's get started. I'll introduce myself. My name is Jennifer Chadband. I am a senior analyst and licensed attorney and also a manager within Zasio's consulting division. And my co-presenter here, Rick, I'll let you introduce yourself.
Yeah, thanks, Jennifer. I'm also a senior analyst and licensed attorney, and I'm a manager in the consulting division at Zasio. I'm also a manager in the legal research division as well.
Great. So the title of our presentation today, mitigating, I should say, privacy risks within your records retention schedule. I wanted to provide everybody just kind of a brief roadmap here, let you know what we're going to cover, and we're going to start with the why of why our clients and why you should be concerned about this for your organization. We're going to talk about some of the fundamentals in the records retention schedule foundation, not only from how the retention schedule is designed, but some of the privacy laws and the privacy foundation as well. And I think that really is an important kind of component to get into our discussion, more of the fine points of integrating privacy with your records retention schedule. And I think you'll see how everything really kind of fits together, and it helps create, help you create a strategy for how you want to address the different privacy requirements within your retention schedule. And our next slide. So let's get started, the why. So this is definitely privacy. We all know, it's not necessarily anything new, but certainly there's been a lot of attention. The stakes are higher. There are new laws with more stringent penalties, more stringent requirements coming about all the time. And of course, some of these much more recognizable than others, GDPR. A lot of this has really been focused on how do we protect personal data, looking at security, looking at the parameters surrounding transfers and storage, and a lot of these different components. I think one thing that can't be overlooked is retention. And this really is kind of that bridge here that we're looking at. How do you bridge this divide between your records retention schedule as an important component of your RIM program with some of these concepts that are coming outside of privacy, some of these requirements. So you'll see here, and these are actually pretty recent instances that have come about, but major penalties coming about, and this is really in relation mainly to not retaining personal information appropriately and consistent with some of these retention privacy principles. So we saw last year, French real estate company over retaining records related to tenants. These are records that include a lot of personal details, sensitive information. Also, German real estate company. Now, this was a huge penalty, but 14.5 million euros for improper data retention. And so these penalties really kind of surrounding that retention concept. This is new, and these are significant. So this is something that we are working more and more with our clients. We get more questions about this. How do we mitigate these risks in our retention schedule? How do we help bridge that divide? So let me hand it over to Rick. And Rick's going to get into some of those fundamental concepts that we talked about that will really set the stage for how we look at integrating privacy directly into the records retention schedule.
Yeah, and these fines that Jennifer just talked about, they're not only international. CCPA also has mechanisms, so does New York. I was just looking at the requirements for CCPA, and it looks like they've got fines and both public and private rights of action for infractions and not following those laws. And some of them really have teeth, because for things like breach, some of those fines are per individual, and so when multiplied, they add up pretty quickly. So we don't have concrete numbers like we do here, because CCPA is new enough that not a lot of those stories are out yet, but it's going to be happening. So. And by the way, I saw a hand raised, but I missed it. But feel free to raise your hands and participate. Feel free to add a comment if you want us just to read off your comments and questions. We're all here to learn together. This is an educational session. So if you've got something to contribute, something to talk about, we want to hear it, and we'll try to read it off if we can. So we encourage participation. So the way that records retention schedules have evolved is important in understanding the challenges we're currently facing with privacy requirements. And to a greater extent, it's also part of it's important to understand records retention schedule history to help us make measured decisions about how to incorporate privacy and keep us from repeating some of those past mistakes that we've already struggled through and we've gotten through. And so we're going to go quickly through it at a high level, but I think it's important to at least talk about the foundation of records retention schedules and where we are today. At a high level, there have been several major innovations in retention schedules, with a common theme being making them easier to use, easier to understand, simpler, easier to keep updated. Retention schedules were more commonly granular in the past, often at the records level, more commonly organized departmentally. This meant sometimes thousands of records in your schedule, thousands of retention periods, lots of duplicates where records were shared by multiple departments, and all of this was hard to manage. It was hard to enforce. The trend has been to simplify by grouping records into categories based on common topics, processes, retention needs, often called big buckets. The trend is also to organize retention schedules by shared functions to remove the need to duplicate categories where they're used by different departments. So functional big bucket is a term that we've got listed there, and it's something that you hear a lot in the industry. For global companies, even functional big bucket schedules are complicated because even if you get down to 120 categories, which isn't that bad, but if you're in 50 plus countries, that's 6,000 different retention periods. And so to keep track of it all and it's just daunting. And so that's how we get into global harmonization. That was kind of the way to try to manage all of this and simplify it. Which to summarize involves determining a global baseline retention period and then allowing for jurisdictional exceptions. And so the hope is that most jurisdictions will be able to follow the global and that exceptions will be fairly rare. That's the hope. There are other strategies too, reducing the use of triggers and where you use triggers to retention periods. Try to limit the number of unique ones. All things to help simplify and implement, where systems are involved and things like that. So, but, we're doing all of this to, because this, creating this retention schedule or having this retention schedule is only the beginning of using it to manage records. It's really kind of the easy part when you think about it. Implementing, educating, enforcing, and maintaining. That's the hard part of it. And so, while a more complex granular departmental schedule does a better job of identifying the exact periods that individual records need to be retained at. They're hard to use, understand, trade on, enforce, etc. And so, we've evolved from there. We don't want to throw it all out. We don't want to throw out everything that we've done to get to where we're at, but there are some things that we can do, to account for privacy and account for some of these situations where privacy is conflicting with this big bucket method. And so, while the common theme of each of these innovations is to simplify, to make the schedule more useful, those steps haven't been out without risk. Remember that the bigger the bucket is of records, the bigger the category is of records, the more over retention of records is going to be present. And that's because we can only set one retention period per bucket or category. And so it's common to set the retention period based on the record with the longest legal or operational need. Often, you can't go below that legal requirement to stay in line with the laws. So the result is over retention of every other record in that category. So, this process of determining which records should go together, which ones should be separated, what the risk is for over retaining, that's all part of balancing this risk of kind of over retaining records with this risk that we've already talked about historically of making these too complex, too hard to manage, too hard to implement, too hard to train on. So that's the quick kind of historical context to bring us up to date. Hopefully everyone agrees with that mostly. I don't see any comments, so I think I maybe got that one right. So now we add privacy. It's a good segue into privacy foundation because privacy impacts that risk analysis in a pretty significant way. Generally, privacy requirements limit the amount of time that records or information containing personal information can be retained. So this impacts retention schedules in a fundamental way because before privacy laws, over retention of private information it's still aligned with the legal requirements and it was a risk determination. Now that there are these privacy laws, over retention of regulated personal information is just simply no longer legal. And so before we explore some of the options of mitigating privacy risk in the retention schedules, let's go through a little bit of a foundation on these privacy laws themselves so that we are, all kind of know what we're talking about together. And so privacy laws generally can be categorized as decentralized or centralized based on which country you're in. There's a lot of disparity in how they're codified jurisdiction to jurisdiction. And I've got the United States listed there as the first example, and I think it's a good example of a decentralized approach where certain topics and certain states are regulated in different ways. HIPAA is a good example of a regulation. It regulates how healthcare entities and associates manage personal health information. So it's a small subset of regulated parties, and it's a small subset of the records that they retain. And so it's topical. Another example is the Children's Online Privacy Protection Act, COPPA, which regulates how operators of websites and online services manage personal information that they collect from children, minors, and what they can and can't collect. So, both of these examples are federal in nature, so they span all of the different states, but they're limited to the categories of personal information like health and children, and limited by regulated party. Some requirements are broader, and the CCPA is a good example of one that's broader. So there are some, states that are implementing some of these broader privacy requirements, still limited to California residents, but I mean, California residents do business with a lot of companies across the country and across the world. So pretty broad, but it is a state setting that regulation. On the other hand, though, we've got these big centralized examples of privacy regulations. And I think the General Data Protection Regulation in Europe is a great example of that. It more broadly covers citizens in all member countries of the EU and broadly regulates the management of personal information. And so, there are derogations at the individual country level, but there's this overarching kind of fundamental part of the GDPR that is codified at the EU level. And so, it's regulating personal information in general. And so those are kind of the two different types of privacy laws generally. And we're going to talk about different ways that privacy laws are different to a greater extent on this next slide here. Well, actually, first, I want to take a step back. Let's talk about the difference fundamentally between privacy laws and retention requirements. A typical retention requirement sets the minimum retention. And so you can see the language right there, must keep records for X number of years. That's the typical type of language that we see. And it sets a minimum retention, but doesn't say anything about where you go from there. And so as long as you're above that minimum, you're gonna be in line with that particular law, that the typical records retention law. Now, privacy requirements, they flip that on its head. They do exactly the opposite. They're gonna use language like must not keep records for longer than something. It might be the purpose for collection. It might have a specified period, which we're going to talk about also. But it's like the inverse. And so those things are kind of pushing towards each other, privacy requirements and retention requirements. Now, privacy laws are also often general, and we've already talked about GDPR, which is one of those, but sometimes they're very specific. And so the general ones, oftentimes they have to be general both in what they're regulating and the retention period, because they're not specifically talking about topics. They're not specifically talking about records. They're talking about this concept of personal information and its retention. And so it's hard to set an exact, precise retention period when you're regulating that broad of a topic. And so that's why they have to use language like no longer than the purpose for collection or no longer than the purpose for processing. And so it's going to be more general in nature. And when you think about it, it could tie to the operational need in the first place for gathering those records. And so if your operational need is actually set based on the purpose for collection, you might already be okay. Your retention schedule might be fine, but that's you got to analyze that. You got to make sure that the purpose for collection does align with the operational need if that's the way your retention schedule is set. And we'll talk a little bit later about some of the analysis that goes into that and some of the things you can do with your retention schedule to figure that out. On the other hand, there are these more specific requirements. And these often regulate some specific aspect of personal information. An example, Texas requires businesses to delete, some businesses to delete any electronic record indicating that a customer has issued a dishonored check. And it's got a 30-day requirement on that, once certain conditions are met. And so that's kind of, more stringent. That's a precise period. And so there's less interpretation, there's less gray and muddy water that goes into interpreting that. You just got to figure out how to deal with that one. And if it conflicts with operational needs for some of the other records in that category, you got to figure out what to do there. So let's talk, I've got 4 examples of laws that kind of demonstrate these different things that we've just discussed on privacy laws. We've already talked about GDPR, but here's the language of it. Keep personal data in a form that permits identification of data subjects no longer than necessary for the purpose for which personal data are processed. So again, we've talked about how it's really broad in nature. Hard to tell, which categories to your records retention schedule that might apply. And so we'll talk about what to do with these types of laws in a little bit. Another type of requirement that we've already talked about, but let's get the language out there so that we can actually see what's going on here. And here are 2 kind of examples of provisions from CCPA. It by no means is all of the CCPA. These are just a couple select sections of it that deal with retention. But again, it's a little bit broad. Personal information collected, although the purpose here is verification of the identity of consumers seeking to exercise their rights under the CCPA as soon as practical after the processing. And so, usually exercising the rights is going to mean asking a company what records you have on them, about them, or how you're using their information, those types of things. And so it is a little bit more narrow, although it could apply to anyone in the United States, any company in the United States that's reaching out and doing business with California residents. And then anytime a consumer requests that their personal information be deleted, the companies have to delete that personal information, and there aren't specific timelines listed there. There's more of a reasonableness perspective to it, but it's pretty set in stone that those records need to be destroyed unless there's a valid operational need or one of the exceptions within the CCPA, which are fairly numerous but pretty specific. The CNIL from France is another great example. This is kind of a good example of a more specific requirement. It's a single jurisdiction, so it's only companies recruiting, essentially, in this case in France. And it requires that that companies destroy unsuccessful job applicants 2 years after the last contact with the person concerned. And so that kind of demonstrates the strict nature of some of these, where there's not a lot of leeway there. There's not a lot of room for interpretation. It's like that category on recruitment. If it's a big mishmash of records all relating to recruitment, and there's an operational need to retain those for longer, other alternatives are going to have to come up, or a jurisdictional exception for France is going to have to be there. It limits the options of what we can do to try to figure out how to deal with some of these requirements. And this type of requirement isn't just international. In the United States, there's an analogous requirement in Utah that requires that information collected about applicants obtained through a selection process need to be deleted 2 years after the day on which the applicant provides the information to the employer, if they're not hired within that 2-year period. And so this isn't just an international thing. I know Europe is leading the front on privacy laws, but I mean, states like Utah have these things too. And so you got to keep in mind that just about anywhere you're at, these types of laws need to be evaluated. And so, that kind of sets up the conflict. How do we reconcile both these general laws and these specific laws with records retention schedules, and what are some strategies to do that? And I'm gonna turn it over to Jennifer now to talk about some of those strategies.
Sure, and we just had a quick question. We had a question come in. Does the entire record in California get removed, or just the PPI? And kind of looking over that deletion request, to that question, it says that you shall delete the consumer's personal information from its records. So if there's a method, it sounds like, to sanitize that and remove that personal information, then that would be acceptable to satisfy that requirement.
Yeah, good question.
All right, so thanks, Rick, for turning it over here. I think that was a really great foundation, and I hope that was helpful for everybody. What we want to look into now is kind of taking these foundational concepts, what we understand about privacy and the requirements that we typically see, and how do we apply this to our retention schedule. And again, taking that retention schedule foundation from our discussion, the idea is that we still want to maintain that integrity of this simplified retention schedule without overcomplicating it. And so there are some strategies here that I want to go over. And can we go to the next slide? Thank you. So if you want to tackle this personal information in your records retention schedule, I think one of the first things you really need to understand is, where is the personal information living in the retention schedule? Where is it? And I think this can be a difficult question because, if you look through your records retention schedule, and if we understand a piece of personal information in some jurisdictions to amount to something as simple as like a very unique name, for example, there's the possibility that every single record series in your retention schedule could include personal information. So what we kind of want to look at is, let's take really a measured approach, and it's a risk-based determination. We want to see and identify the record series that include this PII, and you can make that decision as to how broad you really want to go. I think a good starting place is, let's start with definitely record series, identifying those record series that include highly sensitive personal information. So anything that relates to one's, religious beliefs, anything that relates to health data, there's definitely these categories that fall within that. And then we also see in particular, this also is reflected in the laws. And because it seems like when we have very specific privacy requirements, what they're really oftentimes going at is just getting to this highly sensitive information and creating parameters around its retention. And there's other categories as well, like biometrics is a great one. CCTV footage is one that we would commonly see, and there's a lot of requirements that are restricting the amount of time that those types of records can be retained. So that is a really great place to start. And then you kind of move into other record series, and we like to kind of focus on those record series. Where would we expect to see definitely combinations of personal information? And you can kind of also look to guidance from your retention schedule just from a functional perspective. A good example would be your human resources function. So there's definitely an area where we would expect to see a lot of personal information that relates to employees. Going beyond that, depending on what your organization's operations are, their regulated business activities, you might also be looking in your sales and marketing in relation to prospect contacts or customer contacts. If you are in financial services, you'll be looking potentially at sensitive client information, and then also health sciences, patient information, for example. And so this really kind of will guide where you might want to focus on for doing this risk mitigation strategy, looking at these record series and the retention periods, as well as very specific requirements that relate to particular subcategories of these records, such as CCTV, such as biometric information, and how can we really take a closer look at that? How can we address it in our retention schedule? And so let's go to our next slide here. So where is a good place to start on this journey? What we commonly recommend to our clients, and I think that this recommendation is backed by or supported by what we are seeing and hearing as far as what the data protection authorities are looking at, what some of the laws that are coming out regarding retention periods. Is a low-hanging fruit would be from these record series where you've identified that there's definitely a risk there. There's that personal data that's included. Take a look at your permanent retention requirements. And this is always a really good place to start. It's definitely becoming more and more so. If you are keeping personal information permanently, I mean, that is kind of the first place. It raises red flags in any sort of an audit or review with data protection authorities. So that's a really great place to start. And I'll just give you an example of what we've kind of seen in working with some of our clients. There's definitely some industry common practice, and there's risk-based considerations that go into this. So keeping, for example, like employee exposure records permanently, or in some industries, we have heard or seen personnel records being retained permanently. And going through, taking a look at that record series, you can kind of look at hopefully you have the access, you have the research that supports that. You can really look through and get a sense, what are the legal requirements across my jurisdictions or within my relevant jurisdiction or multiple jurisdictions? What are the requirements? This will give you a sense of, okay, from a legal perspective, these are kind of the minimum retention periods. this is how long we at least need to be retaining these records to remain compliant. And I can say, personnel records, keeping them permanent, with save for a few kind of outlier jurisdictions, that is, you will not commonly see legal requirements supporting a permanent retention period. So aside from that, this is also the opportunity, equally important to consider, is you also, to a certain degree, need to reach out to stakeholders and engage, also understand what some of these business and operational considerations are that are driving the retention periods in your schedule. And so, there are substantive reasons for keeping those the personal data records beyond the legal requirements, and that kind of goes to your initial purpose and that ongoing processing activity that relates to those records. So it's certainly not, completely driven by legal requirements. They are very important, but also important to that is engaging with stakeholders. And of course, I think part of this has to be your privacy team.
And Jen, we got a question that just came in. You mentioned CCTV. Have requirements around those changed in a specific way in the past few years due to privacy issues? I was going to take a stab at that first. I do think that privacy is driving a lot of the records around documenting non-incidents in CCTV, and setting very, very short periods around, CCTV video that doesn't capture any kind of an incident or any kind of activity that needs to be retained for a particular reason. And the reason that it does is because, that footage is oftentimes, capturing people's faces and things that people are doing, depending on where they're located. And so I do think that it is in some ways related to privacy.
Yeah. Yeah, and I'll touch on this here in our next slide too, but to that same point, I think that definitely, you're seeing more and more requirements, and I think specifically in the European jurisdictions, keeping the CCTV footage for no longer than a certain period of time. And it's just very heavily restricted because I think of the risks that people foresee in misuse of that information, especially with a lot of the facial recognition technology that they have nowadays, and even governments using that technology in some jurisdictions. You're starting to see that, and the risk that they perceive with, just having on hand this footage of individuals' faces that could be misused. So it's definitely, I think, more and more something that's more and more restricted.
Yeah, a lot of the laws, the biometric laws talk about how, the picture itself isn't what's important. It's kind of, the way that the data points on the face, and that can be used to identify people in different situations. And I think that the fear is that video provides enough of a, moving around and everything like that, to get some of those template type, that template type data and potentially misuse it.
And I'll kind of speak to that point. I think this is a great example to segue into our next slide. So this is just I think to demonstrate a big bucket kind of issue where you might look and say, okay, I've got an individual coming to me. This is our EMEA contact. They're saying, we have this bigger bucket. It relates to security administration. Within the security administration, we're keeping a lot of different records, and included within here is CCTV footage. And let's say, we're keeping those records for 2 years, but there's requirements across the jurisdictions consistently that are saying, CCTV footage in particular from that business and operational perspective, if it doesn't involve an incident that justifies this ongoing retention, it really should only be kept for a very definitive short period of time. And some jurisdictions are saying it should be retained for no longer than 7 days. And so that's definitely, a departure. So kind of putting your hat on it, looking at your retention schedule, what's the best way to address this? This is a particular type of highly sensitive, highly regulated privacy record that would merit potentially its own record series. So pull that specific record based on these circumstances out and set it for a shorter retention period, because the other records in the bucket definitely have some ongoing value beyond 1 month. So it doesn't make sense maybe to set all of your security administration records at 1 month just to comply with this kind of outlier requirement that's specific to a very particular type of record. And so what we are recommending and what we're seeing our clients do is setting a global retention period of 2 weeks to a month for these types of a record, even recognizing that there might be a jurisdiction or two that requires something shorter than that. But at the very least, you have this record series where that information is specifically kept. And there's many different, I think, opportunities. This type of CCTV footage aside, there's an approach you can do for a lot of these different categories of regulated records. So biometrics is one that we've brought up. So even just fingerprints. The US is seeing more and more of these biometric laws. Currently, we've got 3 states that actually provide privacy laws related to biometrics, including Washington, Illinois, and Texas. And Texas and Illinois have even provided definitive retention periods, basically saying, here is the retention period that is reasonable for you to keep this information. And so there's definitely, I think, as a first measure, what are these highly sensitive, highly regulated categories of personal information that we can separate out and make sure that we are kind of maintaining those very strictly with the requirements in mind as much as possible. And there's some other opportunities too, and it really just depends, what's your tolerance for, for retaining some of these records a bit longer than the legal requirements per se. Are there ongoing needs for the processing? Is it supported by these different business and operational needs? And so our clients kind of are taking different approaches as far as their risk appetite and how far they want to go, while keeping in mind that ultimately the product that they want is they want to keep the integrity of their retention schedule. They still want to have that ease of administration and make sure it's manageable. We've had clients come to us on a very far end of the spectrum where they're literally kind of managing their records, their records that include personal information, one record at a time, so one piece of data at a time, and assigning a unique retention period to those. And it's kind of put them in a bind, so to speak. The maintenance, the cost associated with maintaining the research for every single one of those pieces, as well as how do we maintain this? How do we maintain hundreds of different types of records with very specific retention periods across multiple jurisdictions? And they're finding it to be very unmanageable. So it really is about striking that balance and finding out what works best for your organization and kind of how much more granular you might want to take some of these pieces based on that risk analysis that you do as you look through the retention schedule.
We got another question. How is it determined that 2 weeks to 1 month is a standard or good amount of time, I think, for CCTV?
That's a really great question. So I think that this is definitely something that will be unique for each organization. So we understand what the legal requirements are. That said, equally important, I think, is looking towards those business and operational requirements, your security policies. How long do you need to keep these? And to a certain degree, some of the requirements even address this. So it's an Italy requirement, for example, and they set forth a very short period of time, but they also acknowledge within the requirements that there are certain organizations that this might not be sufficient, and it mentions banks specifically. So maybe a bank has a policy, we need to keep these CCTV footage records for at least 2 months, because we know, we have a process for surveying these, and we need to know in case somebody's actually casing this joint or whatever, we actually need to keep those for a longer period of time. And another issue aside is, and this is where conversations with stakeholders, knowledgeable individuals come in to play, is can you even implement a 2-week retention period? So we've had clients say, we really want to get this retention period down. Let's try a month. And then they've gone and they said, this is actually not something that we can even implement within the CTV system. Like, it has to be kept for a minimum of 90 days. And that's just how it is. So I think that it's not necessarily, this is the right answer for the organization. I think it's kind of the totality of the circumstances and making sure that when you make that appropriate retention period determination, you're considering the laws, you're considering the business and operational needs, ongoing legitimate bases for processing those types of records, and then really documenting all of that when you make that final determination as to what the best retention period is for those records for your organization. So let's go into that next record series. Perfect. So I think some other kind of ideas here, and one thing that we're kind of looking at is there's kind of different schedule designs. I know we talked about big bucket, we talked about departmental. There's also, I think a lot of the preferred method is like, let's have one global records retention schedule. This is easier to manage. We've also seen, and it just depends on your operations, but regional retention schedules are something that our clients are considering. And I think this was a particularly salient after GDPR came out. And, they were like, well, we really should, let's just make, the EU kind of needs its own thing now, but also, our clients are also really forward thinking, like they kind of see the writing on the wall. And so when we have conversations, it's not just like what's going on right now. We see privacy more and more in the US and more in every jurisdiction. It's not really something that's necessarily just GDPR centric. And so our clients are keeping that in mind. That said, we're also seeing kind of some creative solutions. And so that might be even sub-jurisdictional exceptions. It used to be just country exceptions. And even, from a global baseline perspective, I think the traditional idea was for, some of our clients in particular, let's have the US govern that baseline. But with all the jurisdictions considered, they're now thinking, well, in a lot of instances, maybe the US is setting these longer retention periods that we might want to consider as an exception. And even then, is it appropriate to maybe have exceptions for states? And this is coming up more so recently in light of CCPA. And I'll give you an example. New York has a requirement that relates to workers' compensation, 18 years. And that is very much an outlier from the rest of the jurisdiction. So clients thinking about, oh, do we want this to kind of, not only should it drive the retention period for all, the global baseline, should it then be an exception for the US? And even then, should it only be an exception for New York, where we can kind of keep the rest of the states at more of a reasonable retention period of 7 years, and which is more kind of reflective of that. So yeah, there's definitely some kind of creative solutions there. And what were you going to say, Rick?
I was going to say that it's still in a situation in the United States where you're able to do that risk analysis, and you're able to kind of try to figure that out on your own, whether you want to have a state exception or set it all at 18 years. But I think the future is going to be that a state or maybe multiple states enact things that are, similar to the GDPR and regulate, personal information more broadly. And then you might be in a situation where you're dealing with, well, is 18 years really in line with the purpose for collection, or the objective or the purpose for processing, or any of those types of things? And that's where it gets a little bit stickier and a little bit harder. And so, being proactive and setting a jurisdictional exception for New York, and setting the rest of the country at a lower retention that aligns more with your operational needs for collection, I think is probably a way that things are moving.
Thanks, Rick. Let's go to our next slide. And actually, this is kind of our final slide before we wrap up here. So I know this presentation is about mitigating privacy in your RRS, but I think there's also some things that are important to consider in thinking outside of our records retention schedule. I think it's important to remember, and your records management policy should really define, what is considered a non-record, what falls outside of the scope of the records retention schedule. And certainly, personal information is involved in huge volumes of non-records, not subject to, the retention under the schedule necessarily. And so I think making clear that idea within your records management policy or within your privacy policy, so that if this information is being used more of in a transitory way, that they're not necessarily being retained for no good purpose. And then also, of course, I think this is something to think about for sure. And but sanitization. So, which basically, goes to, if within your records, it's feasible to actually remove the personal information from a particular record, or anonymize that information, that personal information, so that it is, doesn't really fall under a lot of these requirements, and is then kind of becomes more or less risk as far as over retention for the organization. To have that as an accompaniment to this, and part of your overall risk mitigation strategy for the retention of personal information, I think that that's absolutely something that's instrumental to consider. And of course, I think a lot of organizations are really overall on top of this, but it really goes, all together here as part of that bridging that privacy concept for the retention aspect of your records retention schedule in particular. So I just wanted to point out those two aspects. And we just have a few minutes left, so we wanted to kind of open it up, and just, if there's any more questions, we would have some time to address those, and we would be happy to talk. If there's any comments and or anything else, we wanted to have that time to open to everybody.
Question just came in. Can you provide an example of non-record personal information? And I had a minute to think about it, so I'll take a stab first. You can take a stab next if you want to, Jennifer. But
Sure.
I think it's going to depend a lot on what you classify as a record, and your policies regarding that. But I think a good one that people are kind of having to deal with right now, and that we've talked about on some of our virtual coffee webinars, is COVID screening. If you're taking the temperature of employees walking into the building, as you're standing there taking that information, and you get the temperature reading and everything's okay, and they get to enter. I think that's a good example. It's personal information for sure, because it's someone's temperature, and you're seeing the person and everything like that. But it's maybe not the type of thing that you want to actually make a record out of and record and write down and everything, just because it's frankly illegal in some countries like France. But even in the United States, it's like, what's the point of documenting
Sure.
that if you've already got a policy saying what you're going to do, and you're auditing the fact that you're doing it a certain way? And so I think that's an example of
Yeah.
non-record.
Yeah, if it doesn't rise to the record of something that might be considered part of like a workplace exposure or something like that, I think that is a really great example. And it's just, personal information is replete through everything that we would consider maybe non-record. So just like copies, of records or drafts or, you know, these types of things that I think already should be kind of clarified and subject to the records management policy as far as non-records and, you know, the retention schedule not applying to them. It's just a matter of making, it kind of raises, you know, it raises the risks with that kind of redundant information laying around when it includes personal data. So it's really just making sure, or personal information, making sure that that's very clear.
I don't think we're going to have time to get to all these. One really quick one, documents attached to emails that want to be kept, that have the attachments have social security numbers. Any way to scrub the social security numbers? I do think there's software out there that can look for formats of personal information and delete that. And I don't know how that works within an email system where it's sitting there and it's an attachment, but I think a lot of the software providers might have stuff to do that potentially. Although I would say, you know, delete those emails, you know, get those records out and schedule them the way that they should be in the retention schedule, and get rid of that email soon. You know, that's what I would recommend. But
We did have some more questions come in. Unfortunately, I feel like we're definitely over on time, but we don't want to keep everybody beyond. And I know there's other presentations going on. So thank you so much, everybody, for joining us. A shout out from Boise, Idaho, and I think it was great. I appreciated everybody's participation and interest, and thank you very much.
yeah, thanks for all the great questions. You guys made this a lot more fun, getting to learn from each other and getting to respond to questions. We love this.
Yeah. Thanks, everybody. Have a great rest of your day.
Thank you.